So thank you everyone for joining us. Sorry, we had a couple of audio issues, so we're running a couple of minutes behind, but I'll talk extra fast to make up that time. So my name's Keris. I'm a Senior Engagement Specialist at the Growth Hub. Just in case anyone hasn't used this platform before, we are basically, it's quite simple. If you want to ask questions as we go along, please put them in the chat as they occur to you. And we might have a break mid-section to answer questions, or we might park them all at the end. So you can jump in and under the Q&A, and there is also a box if you want to ask them anonymously. But just bear in mind that we won't be able to follow those up if there's anything too specific, that we won't be able to. If you tick anonymously, we won't know who that is. Okay, so what is the Growth Hub? So the Growth Hub basically is here. We're a organisation, a project of Cornwall Council that's here to connect you with any free business support nationally at the moment, which is connecting you. So we work with all businesses, including self-employed people, not-for-profit organisations, to help you to grow, to help Cornwall businesses in Cornwall and Scilly to grow. We do that by generally by an online video call with one of our friendly connectors. So that's a free business review where you can talk to one of our connectors and have a whole look at your business, and they can signpost you to the right support. And I'm just going to get in early. This is part 1 of 2. So there is a follow-up to this session. So make sure that you sign up to that. That's with Laura and Chris again, who you're going to see in a minute. So that's on the 17th of March. And not everybody signed up to both. So just make sure that you click and sign. If you like this one, I'll repeat this slide at the end. And we've also got some more events coming up. So we've got a logo branding, strategic branding webinar tomorrow, which is it's going to be really interesting. And then we've got some other ones which are more targeted towards alternative business, CICs, charities, and employee-owned businesses. So we've got ones on finance, recruiting volunteers, ones on different types of business models. So if you're thinking about looking at employee ownership models, and then we've got a couple of ones later in March around bid writing, and then there's also one that I'm doing if you're thinking about applying for business awards. So because we're a sponsor of Cornwall Rewind Radio's Business Awards, which is running at the moment. And to get all the updates, I'm just going to give a shout out to our newsletter, and you can sign up on our website, or there's a QR code there. And I'm going to hand over, I'm going to mute myself. I'm going to be in the background on the Q&A, so I'll jump back on and I'll hand over to Chris and Laura and they can introduce themselves.
Thank you, Keris, and good morning, everyone. Apologies for the slight delay. It's only been about 5 years we've been using this kind of tech, so we're still getting used to it. Just a little bit about the firm, and Keris is very helpfully going to share the slides on my behalf, so thank you for that in advance, Keris. Just as a quick introduction, Laura and I are both from a firm called Stephens Scown. The story of that firm began in 1938 when it was created as a traditional law firm based in Cornwall. Since then, we've grown into one of the Southwest leading law firms, and today we're proud to be both employee-owned and B Corp certified. As an employee-owned firm, that is an aspect that's central to who we are. It reflects that we take a people-first approach where we support one another, tackle challenges together, and strive to go above and beyond for our clients. Our B Corp certification highlights something else that's deeply important to us, a commitment to doing business responsibly. It means we're focused not just on profit, but on making a positive impact for the people that we work with and we represent, for our communities and the planet, holding ourselves to the highest standards in everything we do. We're also proud to be a multi-award winning firm, and just to highlight a few of the recent achievements, we received the Corporate Social Responsibility Award at the Clio Modern Law Awards. We were recognised at the Cornwall Law Society for both Commercial Property Lawyer and Family Lawyer of the Year, and we took home Employer of the Year at the Business Leader Southwest Awards. Our employment team, which Laura and I are both members of, has recently been nominated for Employment Team of the Year at the upcoming LexisNexis Legal Awards. So we're obviously looking forward to seeing how that goes. In terms of us as speakers, thank you, Keris. I'm talking to you today, as is my colleague Laura McFadyen. Our contact details are there on the screen. We are both partners in the employment team, and as a team we cover the full gambit of employment law. So there's not any element of it that we don't cover. In terms of an overview of what we're looking at today, just before we get into the thick of it, I just wanted to take a moment to explain how today's session is structured and what you can hopefully expect to take away from it. The session focuses on what the upcoming employment law reforms actually mean in practice and how businesses, particularly SMEs, can prepare in a realistic, proportionate and manageable way. The aim is to cut through the noise, to focus on what employers actually need to do, rather than simply describing the legal changes. We're going to start with an outline of the April 2026 reforms, looking at the early changes about to affect employers, and then discuss those changes in depth. From there, we'll move into a summary of the further wave of reforms coming in October 2026, including restrictions on new duties to prevent sexual harassment, changes to tipping laws, new rights for trade unions to access workplaces. Once we've covered those off, we'll be turning to a summary of some of the 2027 major reforms that are on the cards. These include earlier unfair dismissal rights and restrictions on zero-hour contracts. There are other things that are coming in 2027 as well, which are also important, but we'll be covering those in our second webinar, which Keris has mentioned, which will be airing on the 17th of March. After we've mapped out what's changing, we're going to focus on the practical implications, looking at what this means for your workforce planning, how SMEs can manage risk while staying proportionate, and the steps that you can take now to future-proof your policies, contracts, and internal processes. We're going to highlight the areas where preparation will matter most, including recruitment, probation, what managers need to know, communicating, training for staff, and record keeping, and share realistic ways to embed those changes without overwhelming you. We want the session to be useful for you and also to be interactive if possible. So we are going to run some polls during the session, which are anonymous. I would encourage you to engage if you're comfortable doing so, and then we'll discuss what those are showing during the presentation. You also have the opportunity to ask us questions using the Q&A function, and we'll look to answer those at appropriate times as Keris has outlined. The session is particularly relevant for SME owners, HR professionals and managers of people, and anyone who is supporting business compliance and growth. By the end, our aim is that you will have a clear, structured understanding of what's coming down the track, and most importantly, the confidence to plan strategically, not reactively. As I've mentioned, we'll be delivering a follow-up webinar on the 17th of March, which is called Future-Proof Your Business, October and 2027 Reforms. So moving on then, in terms of the Employment Rights Act 2025 itself, this is one of the most significant reforms to UK employment law in decades, certainly in my entire career. It's got a phased implementation, which is the next stage of which will be in April 2026. Some bits came in this month, and the clock is ticking for employers of all sizes. Time is short, so it's important to start planning before the deadlines hit. For SMEs in particular, the Employment Rights Act represents a moment of real change. Smaller employers often feel the impact of new rights more quickly because they have less in the way of HR resource to lean upon. They've got tighter budgets often and more informal processes. That means preparation is not just helpful, but we would say it's essential. The legislation fundamentally reshapes workplace rights. Much earlier unfair dismissal rights for employees and increased family leave rights from day one of employment, through to restrictions on zero-hour contracts and new duties to prevent sexual harassment, all of which are going to be quite something for employers to tackle. Many changes will take effect in April and October of this year, with further significant reforms, as I said, scheduled for 2027. This might feel like quite a substantial burden, and we're not here to look to scaremonger. The Employment Rights Act also represents a genuine opportunity for employers in terms of adapting early, embedding fair practices into your workplace to improve staff engagement, and building a more stable and resilient workforce. In competitive labour markets, which that sort of stuff can be a real differentiator. So now's the time to move from mere awareness to action. Whether you're just employing a few people or many more, early planning will help you stay compliant. It will help you protect your organization and create a workplace that's legally robust and demonstrably fair, and build a fairer, more resilient workforce. So on this next slide, we've just got a QR code that links up to the government roadmap on reforms, which was posted on the 3rd, or I think it was 3rd or 4th of February, but was updated on the 11th of February. So I would encourage you to scan a copy of the QR code to take yourself through to the government information. It will be helpful in terms of knowledge and planning for what is ahead. Now, obviously, if you don't get a chance to capture it right now, these slides can be made available to you if you contact Keris, and that's how you can follow up on that. There will also be a recording of this that can be made available. So moving forward from that, in terms of why early action matters, it's because last minute action creates the risk of claims and reputational damage. Early preparation allows time to budget. It allows you to plan for changes such as increased statutory sick pay, paid family leave entitlement, strengthening your recruitment processes, and also your probationary processes with the changes to unfair dismissal rules. You can update your internal systems, ensure that you have the knowledge to take the changes into account, train your managers, and communicate clearly with your staff. For SMEs, that breathing space is particularly valuable. It will help to avoid the pressure and help you make changes that are proportionate and implemented in a way that's planned. It also gives smaller and medium-sized employers the chance to step back and just to take a moment to understand where their current processes might be slightly too informal and potentially inconsistent, and where that might create a higher risk under this new framework that's coming in. It also positions you as an employer as being someone who is proactive and fair. And these are key factors for strengthening a positive culture and attracting employees, supporting employee well-being, and keeping staff in what is a competitive marketplace. So coming back to that interaction point that I mentioned, we would like to run our first poll if technology is on our side, just to sort of gauge the feeling of how ready people are feeling in relation to being prepared for the Employment Rights Act and the changes that's bringing. So you'll see that you've got 4 options, ranging from not ready at all to fully ready. As I mentioned, it's anonymous, so please don't hesitate to be open and honest in your answers. No one's going to know, and hopefully Keris can run that poll for us, and then we can have a look at the results.
So yeah, I don't know if you can see that on the screen there. We've got 50% who are saying that they're not ready at all, and
50% partially ready.
50% partially ready, yes. So
okay.
Nobody is fully ready, which I suppose is why they're here.
Well, and that's perfectly understandable that you wouldn't consider yourself fully ready. And it's really great that people were willing to put their hands up and say, actually, we're not ready on this at all. It is one of those things. The Employment Rights Bill, as it was sort of bumbling around for quite a while, and since it received royal assent late last year, it's sort of coming around quite quickly. So not a problem not to be ready at all. The main point is that you're here and you're getting yourselves ready. So that's great. Laura, anything on those results that springs to mind for you?
Well, yes, definitely interesting seeing that split there between the two. I think it would be almost impossible to be completely ready, because there's a lot of legislation which, Chris, has to be consulted about and implemented. So there may well be changes along the way that we don't know about, and there's quite a lot to be clarified as well. But yes, I completely understand that people aren't ready at all. And again, as you said, it's really great that those people are attending this event. And the good news is that you are attending, you're learning, and you've got time to make the changes before they actually come into effect. The first ones, which I'll be speaking about shortly, which I think will have the most impact for SMEs from April. So yeah, there's a bit of still.
Definitely, and certainly, you know, the hope is that people are going to feel more ready coming out of this webinar than they felt coming into it, which would be, you know, a success for us. Okay, so that's really helpful, and thank you for your interaction. As Laura said, some of the stuff is still unknown, so it makes absolute sense that people don't feel fully ready, because you'll hear bits and pieces from us throughout the presentation around how further regulation is awaited or further clarification from government. So without further ado, then getting into the thick of what is coming, I'm going to hand over to Laura, who's going to talk about the April 2026 reforms.
Thanks, Chris. And just to explain, we'll be swapping between each other to make it a bit more interactive and hopefully interesting for you as the audience. So good morning, everybody. I'm Laura, as Chris said, a partner in the employment team, Stephens Scown, and I'm going to be speaking to you about the changes that are going to be coming into effect from early April this year. So April 2026, in my view, marks the first major milestone in the rollout for the Employment Rights Act 2025 for most employers, and it will bring in a series of reforms that strengthen day one rights and increase protections for employees. So from early April, employers are going to see a number of important changes, and I'm just going to give you a quick summary now. They include new day one rights to paternity and parental leave. Statutory sick pay rules are going to be reformed so that more workers are going to qualify and qualify sooner for that right. The protective award for failure to properly inform and consult in collective redundancy consultation is going to double, so that's significant. And this phase is also going to introduce the creation of a new body called the Fair Work Agency. It's a new enforcement body which is designed to support and uphold employment rights. And there's going to be significant changes about workplace behaviour and how that needs to be handled by employers. Where employees make disclosures relating to sexual harassment soon, from April, these will potentially qualify as a statutory protected whistleblowing complaint. And that means that employees who make complaints about sexual harassment may well have greater legal protections, and employers will have to handle those complaints even more mindfully and carefully than they do now. And alongside this, for larger employers, so those that have 250 plus employees, are being encouraged from April 2026 by the government to put in place voluntary equality action plans, which are intended to address gender pay gaps and also the menopause in order to support their employees. These action plans are going to become compulsory in 2027, and the government has also committed to issuing new menopause guidance for employers to follow, and that's in respect of menopause action plans. So that's due to be published in April 2026 as well. So although smaller and medium-sized employers might not have the same statutory obligations to introduce those equality action plans, when it comes to menopause and gender equality, I think that with those initiatives being introduced as statutory obligations, there's going to be increasing expectations from staff that belong to smaller and medium-sized employers that all employers should be supportive in addressing those types of issues in the workplace. So I think there will be a trickle-down effect there that you need to just be aware of. So quick summary then of the April reforms, which I think set the tone for what the government is intending to be a more transparent, fair and supportive employment law framework. And I think those reforms are kind of basically the start indicating the scale of change that's approaching, with more changes that are due to take effect in later on in 2026, and also some really fundamental changes that we'll be touching on this session and going into more detail in the next session from early 2027. So in the next few slides, we're going to do a deeper dive into some of the April 2026 changes, which are going to be coming into effect pretty soon. So if we can just go on to the next slide. Thank you. So first of all, SSP, statutory sick pay reforms, which are going to be affecting employers big and small from the 6th of April 2026. So what's going to be changing? First of all, the requirement for 3 waiting days to qualify for statutory sick pay will be removed. So currently, statutory sick pay is only paid on the 4th day of sickness absence. And also, the lower earnings limit will be abolished. So that's something that needs to be met if an employee is going to qualify for SSP. So currently, employees need to be paid at least £125 per week to qualify for SSP. So clearly, more workers are going to be qualifying for SSP from day 1 of sickness absence soon. So what does that mean for the calculation of SSP going forwards from April? It means that, well, the implications are, what we know is that employees who have lower earnings, for those individuals, their rate of statutory sick pay will be calculated as either 80% of their average weekly earnings or a standard flat rate, whichever is the lower. So the current rate that would be relevant would be £118.75, but going forward from 2026 to 2027, so this April, the relevant rate will be £123.25. So as I say, if you're a lower earnings person, you would either get that flat rate or 80% of it, whichever is the lower, from the 6th of April 2025. So why does this matter for SMEs? Well, if you're an employer that only pays SSP, which is very common in our experience, there will be an immediate payroll cost. And you may find that there may be some more short-term absences that occur on the basis that employees will then know that if they don't turn up to work, at least they're going to be paid something if they're going to get SSP from day 1. So in my view, that's a change which is likely to affect SMEs most, perhaps with most impact, with those that have part-time, casual or lower paid staff. And the changes will mean that really, as an employer, there should be tighter absence reporting and record keeping in order to stay very fair and consistent and legally compliant on what you're doing. So you might find, as I said, there might be some scheduling strains in terms of shifts, and you might get shorter notice in terms of absences. Your managers may need to field more eligibility and evidence questions for the payment of SSP because it will become more frequent, again, from day 1. And there might potentially be a need for greater absence management of your staff. So it's possible that you might have more commonly frequent short-term absences that you need to address. So actions that employers should be taking now, mindful that this change is going to be happening soon. Have a look at your payroll and consider, do you need to reconfigure anything to ensure that SSP is going to be paid from day 1 and your records are going to reflect that. Also have a look at your staff handbook and your sickness absence policies as well, just to check that those are going to be in line with the new rights. Also review self-certification documentation that you might have in place. So commonly employees will be required to self-certificate for sickness absences from the first 7 days of absence, and do those in fact reflect the new rules on eligibility or not. And make sure that your managers are prepared for these changes. They might need to have more early conversations with individuals about sickness absence, and then also potentially escalate matters. Again, as I mentioned, if there might be frequent or more frequent short-term absences, to try and get to the bottom of them and deal with them in a way that's fair and appropriate. So this is a change I think that you need to anticipate now and factor into your business costs potentially, and make sure that you've got up-to-date and consistent practices and policies in place before the changes take effect in April, just to make sure that everything is going to be smooth and consistent from that date. Next slide, please. So we're going to run another quick poll just to find out, as a matter of interest, what type of sick pay does your organisation provide to employees? Do you simply pay statutory sick pay, which again, as I said, is really common, or do you pay an enhanced rate instead? So we've got some results, I think, that are coming through. Is that the voting finished, do we think?
I think that's more or less everyone. Yeah, I think we've got about 75% are on SSP and the rest are on company sick pay, enhanced rates.
Yeah, so that's interesting. So I think it shows that actually it is a change that's going to be affecting, quite clearly, 3/4, definitely, of the people who are watching this webinar. So it will have an immediate impact on those who simply pay SSP at the moment. I suspect it will also have an impact on those that pay company sick pay as well. There's a limit on statutory sick pay of 28 weeks, and I'm not sure that all of the people watching this webinar will pay 6 months or so worth of company sick pay that would include statutory sick pay. So I'm assuming that it's likely that everybody will need to take these changes into account. And also it's worth noting that the government made an observation that if you've got people that are coming back to work on a phased basis, let's say you've got someone who's coming back to work after a long-term sickness absence, and they come back on maybe 3 days a week, working their way up to full-time. Again, if they work 5 days a week, then they would automatically get paid statutory sick pay for those days when they're not at work, and that wouldn't have necessarily operated in the same way previously. So I thought that was quite an interesting point just to note. Chris, I don't know if you've got any observations on statutory sick pay you want to add?
Yeah, I think that split broadly reflects what I tend to see in practice in terms of my client base, and those who are limiting it to SSP only, and those who are paying a more enhanced rate. I know some people will pay an enhancement in the form of just covering the waiting days. So it'll be interesting to see what those employers do when there are no longer those waiting days to cover. But yeah, absolutely. I mean, I think it was suggested at one point it was something like an extra 1 million people were likely to qualify for SSP as a result of these changes. So it's a potentially significant extra consideration for employers to make.
Yeah, I think it definitely is. Okay, so moving on to new family leave rights from April. So what's going to be changing with these? Well, paternity leave and unpaid parental leave are going to become day one rights, removing any service requirement. So currently with paternity leave, fathers are required to have 26 weeks continuous service to take paid statutory paternity leave, which is assessed at 15 weeks before the expected birth week. And with unpaid parental leave, and I know it's not exercised that often, but employees who have a child under 18 must have 1 year's continuous service to take unpaid parental leave, which can be useful for some individuals, let's say maybe over summer holidays, something like that. Again, these requirements are going to be removed by the Employment Rights Act, so that they will become day one rights. So they will take effect from the first day that somebody starts working as your employee. A further change that's worth noting is that statutory paternity leave is going to be allowed to be taken after shared parental leave. That's different to unpaid parental leave, and shared parental leave is where a mother opts to, in effect, share her maternity leave with her partner, and it can be flexible, and one can take it when the other one returns to work, or they can go backwards and forwards, they can take it at the same time. Currently, employees lose entitlement to statutory paternity leave and pay if they take shared parental leave and pay before exhausting, so using their paternity leave entitlements. And that change is intended to give partners more flexibility about when they take their leave. And then an added point is bereaved partners' paternity leave. That's a new right, and it's going to enable bereaved fathers and partners to take up to 52 weeks of paternity leave if the mother or primary adopter dies within the first year of the child's life. And that's for bereavements which occur on or after the 6th of April 2026. So do these changes matter for SMEs? Yes, they do. As I mentioned, new starters could be exercising those rights immediately once they start work, and that could affect your resourcing in terms of staffing. You need to ensure that you've got clear processes in place to ensure that there's fairness when individuals are wanting to take those types of family leave, and avoid complaints and grievances if people are unhappy. How will it affect you day to day? You need to be prepared in advance in order to deal with these leave requests and think ahead about handovers between individuals, and make sure that you've got good coordination when it comes to line managers, HR and payroll when individuals are exercising these particular rights. So actions that you should be taking now, I would suggest, would include updating your policies. So you may well have to amend what you've got in place already in terms of when individuals might qualify for those rights. As with statutory sick pay, I think it's fair to say that in my experience and Chris's, individuals, employers who are SMEs and larger will very often just provide statutory leave entitlements and pay, which is absolutely fine. But if there are changes, it means that you'll need to update them. And if you need any help with this, then of course let us know. As a firm, we've got lots of clients who are requiring these changes to be made, and we've got a rolling programme of us assisting them in updating and amending contracts and policies and procedures. So if you need help, then reach out to us, and we'd be happy to help with that. Next, I was going to speak about further changes happening in April in relation to sexual harassment disclosure, which I touched on very briefly. So what is changing there? So if an individual makes a report about sexual harassment in the workplace, that might qualify from April also as a protected whistleblowing disclosure. So not just protection under the Equality Act, which would normally protect an individual making a complaint like that, but also whistleblowing protections as well. So currently, under whistleblowing legislation, individuals who disclose a breach of health and safety obligations by their employer or another breach of the law are protected as whistleblowers if they reasonably believe that their disclosure of that information is in the public interest. So it doesn't just affect them, it affects a number of others as well, potentially. That means that sexual harassment complaints can already be disclosures, so will be disclosures if they meet those thresholds. So essentially, if somebody makes a complaint now and it's also a breach of a health and safety obligation, or it's a breach of existing law and it affects a number of people, so it has a public interest aspect to it, then it might be protected as a whistleblowing disclosure as well. But under the Employment Rights Act 2025 from April, when you disclose a complaint of sexual harassment, it will be added explicitly as one of the protected qualifying disclosures under whistleblowing protection, as long as it meets the test of reasonable belief. So if somebody reasonably believes that their complaint is correct and it's made in the public interest and meets some other tests that would be relevant to a whistleblowing complaint. It's important to be aware of, not least because for whistleblowing complaints, an individual can claim uncapped compensation, and that's a risk if an individual has been treated to their detriment or dismissed and that can be linked to the disclosure that they've made. So why does this matter for SMEs? It's definitely worth being aware of, because even what you might perceive as an informal comment from an individual could trigger a whistleblowing protection. Often we find that managers in small and medium-sized employers wear multiple hats, so they have lots of different responsibilities, and they might hear a complaint which has been made about sexual harassment and not necessarily know that that also might count as a whistleblowing complaint. So it's important just to make sure that people are on the ball with these types of things, have the knowledge to recognise what's happening, and identify what would be the best course of action to deal with a complaint like that. So it's helpful if you're rolling out training, which we suggest should be done regularly anyway, on how to deal with sexual harassment issues in the workplace, to make sure that these points are covered as well, and make sure that you've got clear reporting routes, that staff know that if they raise a complaint like that, they're not going to face retaliation, and that you keep clear investigation records as well. So actions that you should be taking now would be updating whistleblowing and anti-harassment policies so that they've got cross-references to each other, to make sure that managers are well trained and keep records about these types of complaints, and that staff know what they need to do if they want to raise a complaint like that, and what they can expect from you in response. And it's worth mentioning that if you deal with these types of complaints early, once you become aware of them, then you're going to significantly reduce the risk of potentially high value claims. But I think it's really important to mention that if at the moment you are confident that you're dealing with complaints of sexual harassment carefully and compliantly already, in line with equality and anti-harassment and bullying procedures that are well drafted that you have in place, and that you're training staff on how to deal with issues like that, then the likelihood is that you're probably going to be ticking the boxes already if somebody brings a complaint and it qualifies as a whistleblowing complaint at the same time. This new reform, in my view, is in effect giving employees another statutory right on top of a layer of protection that they have already under the anti-discrimination legislation that we have in place. And it's adding again another sort of layer of complexity for employers here. But if you're dealing with these types of complaints well, then they're likely to be fine. We'll be speaking a bit later on about changes that employers have in terms of obligations and how they have to deal with sexual harassment complaints from October 2026, because there's going to be some other obligations there as well. And it's worth just mentioning too that we are regularly giving training to employers in the workplace, so that includes to managers, to staff, on how to deal with these types of complaints, because there have been some recent changes in the legislation, and the way to kind of deal with potential complaints and show that you've been compliant as an employer is to provide that training and roll it out to your staff. So next slide, please.
And that's over to me now. So thank you, Laura. Really important changes that are coming in, and some great practical advice that you've been able to share there. We're running ever so slightly behind time, so I'm just going to touch on some of these slightly more briefly than I otherwise would have done, but primarily because they don't tend to impact SMEs particularly. So the first thing that's coming up from April 2026 is that the process of recognising trade unions is going to become easier. Obviously, although it is rarely something that SMEs tend to encounter, if you do find yourself in a situation where there's a trade union seeking recognition to represent a bargaining unit within your business, then do seek advice. The recognition process is quite complex at the moment if it's not voluntarily agreed to by the employer. And a union can commence an application for statutory recognition, so it can seek that recognition through the Central Arbitration Committee, and it's able to do so where there's an employer with more than 21 employees. Now, as part of that process, what they have to be able to do is at the outset, they have to be able to show that they, of the bargaining unit, so the group of workers that they're seeking to represent, that at least 10% of that unit are members. So that is a threshold that currently exists, and the suggestion is that the potential will be in the future that that can be varied. So the legislation provides for that to be no more than 10% as a requirement, but no less than 2%. So obviously, if you had a government reduce that threshold down significantly, then that makes it easier for a union to gain that recognition. The other aspect that's changing is in relation to a 40% rule. So if you get to the stage with the Central Arbitration Committee where they're satisfied that the tests have been met to run a secret ballot, then what needs to happen as part of that ballot is that the union has to secure two things. It has to secure the majority of the vote, but it also has to secure at least 40% of the employees who are in the bargaining unit that the union seeks to represent. Now, what that 40% means in practice is that low voter turnout can really undermine a union's ability to get recognition. Because if you imagine, for example, you have a group of, say, 100 people, and only 50 of them turn out to vote, then the union's only got to get 26 yes votes in order to secure the majority. But because the bargaining unit is made up of 100 people, they have to secure 40 yes votes, or 80% of it, in order to pass that 40% threshold. And so what the Employment Rights Act is going to do is it's actually going to remove that 40% threshold. So practically may not have much of an impact on those who are watching today if you are within SMEs, but still it's something that's important for you to be aware of as something that is changing. Moving from that then to protective awards. Many of you will have heard of collective consultation, and that is an obligation that arises when an employer is proposing to dismiss 20 or more employees as redundant within one establishment within a period of 90 days or less. Now, that triggers under the legislation which is referred to as TULRUCA, the Trade Union Labour Relations Consolidation Act 1992. That triggers an obligation to consult collectively with those affected employees. If an employer either doesn't do that or they fail to do it properly, then employees can claim to the Employment Tribunal for that failure, and they can seek what's called a protective award. And that is currently 90 days actual gross pay with a potential 25% uplift if the ACAS Code of Practice on Dismissal and Re-engagement applies, but it's 90 days actual gross pay per affected employee. So it can prove to be quite an expensive thing. Now, to sort of sharpen the teeth on this, if you will, the government is changing the law so that it will actually be doubled to 180 days. So that's obviously a significant increase, and it's important why for why SMEs in particular need to try and avoid getting this wrong. So as to why it matters to SMEs, well, it's a severe financial penalty, and it is designed to be punitive, okay? So if you're rushing a process or you're skipping steps in a process, then you are exposing yourself to the possibility of a much increased award being made to those affected employees. And it's also important to remember that although it talks about proposed dismissals by reason of redundancy, the term redundancy is considered very broadly under TULRUCA. And as a result of that, employers can find that they've crossed the threshold triggering collective consultation, even in the context of something like a restructuring. So it is something to be really, really alive to. In terms of how it affects you day to day, it's about sort of pre-planning. So you need to make sure you've given yourself the time to elect representatives as part of the collective consultation process, and that you're able to consult meaningfully with those representatives as well as part of the individual consultation you'll need to do as well. It needs well-drafted letters informing staff of what's happening, why it's happening, when it's happening, When you're having meetings, you need to take good notes of those meetings so you've got a good audit trail, and be clear about your timetables. So it can be very expensive if you don't comply. It can result in litigation, which is not only expensive financially, but it's a significant time drain, and also could carry reputational damage as well. So again, just something to be alive to, that collective consultation can arise in some unexpected scenarios, and the punishment for getting it wrong is going to be doubled. So turning next then to the Fair Work Agency, the new Fair Work Agency that Laura has touched on briefly. I think this is for me personally, one of the most interesting things that's coming out of the Employment Rights Act. So it's a new public authority that's intended to combine existing enforcement functions, such as that which are currently held by HMRC in relation to minimum wage, for example. And the idea is it's going to put those enforcement functions into a single place so that employees know where they need to turn to for help. Now, over time, the Fair Work Agency is going to take on more enforcement rights, including holiday pay and SSP, we expect. And there is flexibility in the legislation to give them further rights again. So it's going to have a sort of growing brief as it beds in. It will, however, take a bit of time for the functions to move across. So it may well be that, I gave the example of HMRC enforcing national minimum wage. It may well be that they will hang on to that for a little while whilst the Fair Work Agency gets its legs underneath it. The aim of it is to strengthen compliance across the labour market, including within small and medium businesses. And so alongside using its enforcement powers where there is malpractice, there's also an intention that it will be there to support business and to support compliance with the law and to help avoid future infringements. So it's kind of got a bit of a dual purpose approach. So again, in terms of why SMEs need to pay attention, well, the Fair Work Agency will be able to take enforcement action for failure to pay certain statutory payments to workers. So when there's been underpayments, as I mentioned, including in due course for underpaid holiday or underpaid statutory sick pay. It can require employers to keep adequate records. It can take steps on behalf of a worker. It can actually step into their shoes and take steps on their behalf as well, which is a particularly interesting limb to it. And we're not entirely sure how that's going to work yet or how that's going to be funded, etc. Save that government have said it will have the funding it needs. So it will have the power to require people to attend meetings, to answer questions and or provide information or documents by a specified date where it reasonably believes that the individual is able to provide information necessary for enforcement purposes. Enforcement officers are going to have the power to even enter premises to inspect documents or access computers or other equipment, which is quite a significant step. It will, however, need a warrant if it's going to be entering a dwelling. So easier for it to enter a business premises than a dwelling. And no one can be required to provide documentation that's covered by legal professional privilege. So if you've had legal advice, for example, that's not something that needs to be handed over. From an employer's perspective, careful record keeping becomes even more important once these new powers come into force, quite simply because mistakes are going to become more costly. The Fair Work Agency will be able to issue a notice of underpayment, which will require the liable party, i.e. the employer, to pay a sum due to whoever it is that's been underpaid. And that sum will have to be paid within 28 days. But on top of the unpaid sum that needs to be paid, there will also be a 200% penalty on top. Now, that penalty is payable to the government. It is subject to a maximum of £20,000 and a minimum of £100. And if it's paid within 14 days, it will be cut in half. Only the penalty is cut in half, not the underpayment. So it can be particularly risky for SMEs where maybe there's some rigidity within payroll systems, there's use of seasonal staff, there's variable hours workers, and that's where we often see, for example, holiday pay errors. So that's something to really be alive to. In terms of the practical impact, obviously expect higher consequences for non-compliance, as I've explained, including the agency being able to recover its own costs. And it's really just important to make sure that you've got that audit trail, sort of harking back to GCSE or O-level maths days where you need to be able to show you're working out, quite frankly. So yeah, really interesting to see how that develops. So then finally on this piece for me, the next bit is in terms of voluntary menopause and gender equality action plans. If I can have the next slide, please, Karis, thank you. So since the 6th of April 2017, employers with 250 or more employees have been required to publish gender pay gap reports. And the first of those was due in April 2018. Under the Employment Rights Act 2025, those same employers, so those employing 250 people or more, will now be required to develop and publish what are referred to as equality action plans. And those need to detail the evidence-based actions that they're taking to improve gender equality amongst their employees. And that must include addressing the gender pay gap and supporting women during menopause. The intention is for employers to become more motivated to take meaningful steps to help employees thrive. And it's expected that these plans are going to need to be published annually. It's also bringing in outsourced workforces within that scope. So organizations large organizations will be required to report which companies they outsource to. The idea being that you want your connected associated companies that you're working with to be reputable as well. And that might place some pressure on other companies. So the measures are expected voluntarily from April 2026 and expected to become mandatory in the spring of 2027. But again, it's just for employers of 250 people or more. So why does that matter to SMEs? Well, what we're expecting is that there will be a trickle-down effect. Larger employees are going to set the new norms for transparency and fairness. Employees and job candidates are going to start having certain expectations of all employers, including SMEs, to show how they support gender equality and manage menopause at work. So that's going to likely become part of what being a good employer looks like, not just for those above that employee threshold. But also from a practical point of view, it helps avoid the risk of discrimination claims, it promotes a positive culture and should be beneficial for staff well-being. So in terms of what you can do in readiness, either as a large employer or an SME, create a simple voluntary action plan on equality and menopause support. It doesn't need to be complicated, but just get people thinking about it. Review your policies as they exist at the moment in terms of flexible working, absence management, and equality to ensure that they are clear and supportive and that everyone understands and is implementing those consistently. Start collecting and reviewing your basic workforce data, looking at, for example, your gender split, to understand any gaps or risks, and train managers to be confident about having those conversations, but having them fairly and aligned with staff well-being. So something of a whistle-stop tour then. Apologies for that, but obviously we were trying to catch up a little bit of time. So I'm going to hand back to Laura now, who is going to talk about the changes that are coming in from October 2026.
Thank you, Chris. Yes, so we've got, I think, maybe a couple of slides or so on this. This is the second major wave of changes under the Employment Rights Act 2025. So we've got all the changes in April that we've briefly run through, and then we've got the set in October as well. So we'll be running over these again in our next webinar in more depth in March. But we've wanted to, in the meantime, pick out some of the most relevant points for SMEs so that you get the headlines and understand what's going on. So I mentioned before, stronger duties to prevent sexual harassment. So we've got that whistleblowing point that's happening in April, but we've also got new duties which are coming into effect from October 2026, which are really significant. So first of all, there will be a stronger duty to prevent sexual harassment on employers. So it's going to be a step up for employers. At the moment, employers need to be able to demonstrate that they've taken reasonable steps to prevent sexual harassment in the workplace. In October, that's going to change to having taken all reasonable steps. So that is a significant change there. And to keep in line with that, what actions does an employer need to take? Well, I would say that you need to review and update your harassment policies, or anti-harassment policies. Make sure that you've got clear and accessible guidance that staff actually read. It's not a dusty policy that sits in a desk somewhere. Make sure that you've got short practical training in place. I mentioned that previously as well. Keep it simple but regular, for example, annually, and you might want to have something in place for new starters as well. Include real-world examples that are relevant to your workplace about scenarios that might take place and what actions you would expect staff to take in your workplace. Risk assess your environment, so identify what you might refer to as hotspots. So might there be situations where staff are particularly at risk? For example, if there's late shifts and they're on their own with maybe a customer-facing role, if they're lone working, and implement safeguards to take account of that. Make sure that you've got good reporting channels in place that staff are aware of, that they know exactly how they would raise concerns, and create a simple documented process that could be used. And obviously keep evidence as well. You'll need to be able to demonstrate that you've taken steps if issues arise. It is a little bit of a quirky point, but the regulations that are going to detail the statutory steps in order to take all reasonable steps are not going to be coming into effect until 2027, 2028. So although this obligation is coming into effect in October, it's going to be after that point that there's going to be statute in place that tells us exactly what an employer needs to do. In the meantime, I would strongly advise that you look at guidance from the government. At the moment, there is non-statutory technical guidance on the Equality and Human Rights Commission website, which I advise that you take into account and just keep an eye and see if that's updated as well. It's really important because claims will be easier to bring and there'll be financial penalties if employers don't follow those steps. So you want to show that you're taking active preventative steps rather than reactively handling issues like that. And again, from October this year, there will be liability for third-party harassment. So from that point, SMEs will become explicitly liable for harassment from customers, clients, suppliers, and other third parties unless they took all reasonable steps to prevent it. So again, what you want to do is make sure that you've got updated handbooks and policies that reflect that this will soon become part of your explicit legal duties that you have to your staff. Make sure that staff are trained on what they need to do if there's problematic customer or third party behaviour and who they should escalate concerns to as well. Have some kind of incident logging process. It doesn't need to be complex. It could just be a shared spreadsheet that your managers could work from, and communicate that there's a zero tolerance from you as an employer to these types of events taking place, so that your staff know that themselves. And you might want to make it explicit also. Let's say if you work in hospitality or retail, there could be signage that's up, there could be recorded messages that we all hear from time to time if we call up and go through some kind of call centre or call leaving process. And you could also implement these types of messages in your agreements that you have for professional services that are being supplied into your workplace. It matters because, again, you need to take care of your staff. There are potential claims that could happen as a result. And it's worth noting that with liability for third-party harassment, it applies to all types of harassment in your workplace, not just sexual harassment. And it's particularly important for SMEs that have customer-facing points within their business, or where there might be regular contact between staff and third parties. And I wanted to touch on the fact that there will be a tightened obligations for employers in respect of tipping rules, and there will be a consultation duty on employers in respect of that as well. So we've got existing 2024 tipping rules that are going to be strengthened from October 2026. And under these new rules, businesses who have a tipping process within their workplace must consult workers or representatives of workers when they're either creating or reviewing their tips policy. So what should you be thinking about doing now? Make sure that all your qualifying tips under the legislation are passed to staff and that your written policy is up to date. Plan a simple consultation process that happens. I think you've got to review it every 3 years. So set up reminders for yourself that needs to be done. And there's an obligation to share anonymised feedback from your consultation with staff with them. So consultation on a tipping policy is soon going to become mandatory, and you need to be reviewing and updating, involving your staff from October 2026. So the idea is to have some kind of transparent system that's in place, and I guess the intention behind it is to reduce disputes. And if you have a good tips policy in place now, that's really going to stand you in a very good place going forwards. And it's certainly something you'll want to review from October onwards. So next slide, please. Chris has touched on trade unions, and I will touch on it very briefly for you, because I think that some of this is perhaps more relevant to larger unionised employers, but some of it is definitely relevant to all. So there's going to be increased obligations on employers, new obligations in terms of union access to workplaces. So again, from October, unions are going to have a statutory right to access workplaces. That's with the intention of recruiting new members and organising and having collective bargaining, so discussions between employer and employee representatives about things like pay and working conditions. It's worth being aware of now, in case it's something that might affect you going forwards, and thinking ahead about how you would deal with having a union coming into your workplace. And it's something that can include virtual and digital access as well. So it's possible in the audience there might be some employers that are within more sort of unionised types of work, and others for whom that isn't particularly relevant. But it's a heads up really that if you don't comply, there could be complaints made to the Central Arbitration Committee. There could be financial penalties for non-compliance as well. Perhaps more importantly, there is a duty on all employers to inform employees of their right to join a union. So you can see that the Labour government is really trying to bolster and support union membership across all sorts of different employers. And the key message in relation to this is that from October, all employers must explicitly inform their workers in terms of written particulars which are issued when somebody starts employment with you, that they have a right to join a trade union. So that from that date, you will need to have up-to-date onboarding materials that are compliant with that right, which will include the required statement about trade union membership. There was a consultation about that particular process, which ended a few months ago, and we're waiting for the results from it. So we don't yet know entirely what form that information is going to have to take. But once we do know, you will have to take action in terms of preparing up-to-date templates which are compliant. Make sure that your managers who are involved in issuing that type of paperwork understand the duty, and that they need to let people know that they can join unions, and to avoid saying something that might discourage union membership as well. So it's going to be a mandatory obligation, and if you don't comply with it, there could be some compensation risks around it as well. And then the third point is employment tribunal time limits are going to change, and it's expected that that's going to take effect from October 2026. So at the moment, you may well be aware that time limits for most employment tribunal claims are currently 3 months from the act that you're complaining about. It's going to be extended for almost all claims from 3 months to 6 months. So that includes for claims like discrimination and unfair dismissal, the exception being breach of contract claims, where the time limit will remain as it is. So what should you be doing about this and thinking about in advance? Make sure that you are perhaps not relaxing after a few months' time, thinking, well, a claim is going to be brought against me. There's going to be a longer time limit. And if early ACAS conciliation is involved, that's definitely going to extend it rather beyond the 6 months. Make sure that you are keeping good records, and that if there's evidence of investigations and fair processes that have been carried out, that's kept. Make sure that your managers know that that's what's going to be happening going forwards. Think about using early conciliation if you've got issues in the workplace, which would avoid disputes perhaps escalating into the extended claims window. And what matters is that if you've got longer time limits, overall it means that you've got wider, longer litigation exposure. And if issues in your workplace aren't dealt with properly at the relevant time, it just prolongs workplace uncertainty in respect of potential claims that might be brought, and financial penalties that you might have going forwards. So I'm handing over to Chris.
Thanks, Laura. Again, lots to consider, but good to look at these things through a positive lens. So just very, very briefly, because as we've said a few times now, we do have another webinar on the 17th of March, which will be focusing in part on the 2027 changes. But some really key headlines for employers in relation to what's coming in. Firstly is in relation to unfair dismissal. So the government had originally intended to make unfair dismissal protection a day one right. But following a series of defeats in the House of Lords, they abandoned that and compromised with this new position, which is that the qualifying period for being able to claim ordinary unfair dismissal will reduce from 6 months to from 2 years to 6 months. Now, my research suggests that it hasn't been that low since between 1974 and 1979. When the right not to be unfairly dismissed was first implemented into law. So it's a significant change. Things that employers are going to need to be really alive to are, in particular, probationary periods. So I see an awful lot of employment contracts that talk about a 3-month probation period with a right to extend it by another 3 months. Well, if you got to the end of that second 3 months, that person would by that stage have accrued unfair dismissal protection, because you can't dismiss someone within the last week, because statutory minimum notice is a week after someone has been employed for a month, and that would be treated, we expect, as pulling them through to accruing those rights, much as it does at the moment in relation to someone with 2 years. So it's good in the sense that the talk previously about light touch procedures and things like that seems to have fallen by the wayside, and we've got a much clearer scenario. The changes going forward will, if ever another government wishes to change this, they will need to enact primary legislation. So the Labour government is making it harder to be changed in the future. So it may well be that we're left with this 6-month threshold for quite some time. Second major change is in relation to the uncapping of awards for unfair dismissal. So as things stand currently, there is something in place called the statutory cap when someone brings an unfair dismissal claim. And that means that the maximum compensatory award someone can receive is either 52 weeks pay, or as it stands at the moment, £118,223. It's whatever's the lower of those two things. So actually the removal of that £118,000 cap is really only going to benefit particularly high earners, and also those who have maybe haven't got very good re-employment prospects, whose ongoing losses are going to be higher. Now, interestingly, the statistics from 23-24 suggest that only 6% of cases exceeded an award of £50,000, and the mean average for that same time was £13,749. So it's still something to be aware of. It might mean, the idea behind it is that people will be less inclined to try and bolt on discrimination claims or whistleblowing claims, or something that, if they can succeed on, would remove the statutory cap from the unfair dismissal element of their claim. So it's got some logic behind it, but remains to be seen what kind of practical effect it will have. But certainly SMEs need to make sure that they are being very careful about their processes and to take early legal advice if they're looking to manage someone out anywhere near that sort of 6-month mark, or beyond it, or if it's in any way contentious. The final quick headline then is that we've got lots of changes coming to 0 hours contracts. It's stopping short of the so-called ban on exploitative 0-hour contracts, which was never really clarified by the government. But the 3 kind of limbs that they're going to be implementing as part of the Employment Rights Act is that there will be a duty to offer guaranteed hours, where someone has worked either under a 0 hours contract or under what's called a low hours contract, and they've worked over their minimum guaranteed during a reference period. We don't yet know what that reference period is, but everything points to it being something like 12 weeks. So headline 1 is that there's going to be this obligation on employers to offer guaranteed hours, and therefore move away from the use of 0-hour contracts potentially. There's also going to be a requirement to provide reasonable notice of shifts, which is a requirement that doesn't exist at all at the moment. The idea behind that is to help people better plan their lives, etc. So we'll be delving into that as well. And then the sort of third headline in relation to 0-hour contracts is reasonable notice of any change or cancellation of shifts that someone reasonably believed that they were going to be needed for. Now, what is going to come in is a compensation system, whereby if you are giving short notice of these things, then you are going to have to pay compensation to the affected employee. That compensation is going to supposedly need to be proportionate to the level of curtailment, if it's just a change, or to the notice that's being given if it's a cancellation. But certainly there's a lot still to be seen in relation to what that's actually going to look like. So in the same way as we yet don't know what the reference period is going to be, we don't know what this compensation is going to look like. But it does mean that employers need to start thinking about those situations where perhaps they ask more people than they would possibly need to have on a shift, because they want to sort of have the numbers, and then they just sort of stand down everyone else when they've got enough. That might start causing issues. So you want to sort of make sure you're looking at how it is that you're planning your shifts and you're rotating your staff, etc. So very much just headlines in terms of what's coming up. So we will touch on that in much greater detail on the 17th of March. And hopefully many of you will be there to hear us talk about that. But for the final leg of this, we're just going to do a quick poll in relation to unfair dismissal concerns. There was going to be a 4th poll, but I think we can avoid that later on in the slides, just because we're running slightly short on time. So if people could have a look and see what their biggest concern is in relation to this change on unfair dismissal. So we've got 1 for the administrative burden. I can understand why that would be a concern. Increased risk of claims, yeah, definitely. Another 1 for administrative burden. I mean, certainly there is going to be an increased risk of claims because people are potentially going to get there sooner. So when employers delay, as often I see, because perhaps someone doesn't want to have the difficult conversation, it's going to be much easier for someone to have sort of slid into that position of having unfair dismissal protection, and then potentially it being a bit more of a difficult management exercise. But yeah, the majority seem to be concerned about the administrative burden, which hopefully is a good thing, in the sense that you can pre-plan, you can get your systems in place, you can review and update your processes, and sort of get used to the new world of work that we'll be in. And obviously there's concerns around cost implications as well. Any thoughts on those results, Laura, before you start your final leg of the training?
I think they're all valid concerns. I can see why they've been raised by people. But I suppose it's just thinking ahead, isn't it? Really making sure that fair processes are used, so that you're in the best possible position as an employer, and at the moment it's not entirely comfortable for employers, but there is a bit of margin in that if there aren't day one type claims that somebody can bring, like whistleblowing or discrimination, it's a lot easier to dismiss somebody without, with a lighter touch process, which you have to go through. It's far more likely you'd have to go through at a much earlier stage going forwards.
Yeah, definitely. I mean, and I certainly see in my line of work, people have put these conversations off for a long time in the hope that someone will improve, or maybe it will just resolve itself, or you have very long extensions of probationary periods, and those kind of things are just going to create greater difficulties for employers. So forewarned is forearmed, as they say, and I think it's, people are going to have their efficient processes. Well, I'll hand over to you now, Laura, for your final bit for me.
Okay, well, this is the final bit of the presentation, and we're just kind of drawing it together on practical steps that you can take, and we've been mentioning them anyway throughout, but I wanted to highlight to you, there's an article that I wrote and have updated recently on 10 HR actions that you can take to get ready for 2026. So you've got a QR code there, and I'm going to run through a bit of a summary of some of the relevant points in the next few slides briefly with you as well. So step one, I would say create a simple Employment Rights Act compliance plan. So identify which changes are going to affect your business the most and when they're likely to take effect as well, and prioritise those actions based on risk as well, and date order. Make sure that somebody is going to be taking responsibility for those action points, and you might want to build in some check-ins, maybe monthly or quarterly, to track your progress on that. And Chris previously shared a QR code for the updated government roadmap. In effect, it's a plan of when things are going to take effect, and you can just Google and find it. But I think that's an excellent starting point for your plan. Next slide, please. So be proactive and review and update contracts and policies. Again, that's something we can help you with if you would like. And there will be some high-risk areas that are worth focusing on. So things like probationary periods, dismissals that Chris has just talked about, flexible working that we'll be talking about in our next webinar, and family leave as well. And I've spoken also about protection against sexual harassment, so policies linking to that too. Make sure that your updates are simple and practical, so they're easy for managers and staff to follow too. So I've listed out some points there that would be relevant to update, which I just mentioned. So if we just move on to the next slide, please. And alongside that, make sure that your HR policies, systems can handle the changes too. So your systems don't need to be complicated. Your priority is keeping accurate records and anticipating when the changes are coming so that they're all up to date. So make sure that things like timesheets, your basic HR system, if that's what you use, or a spreadsheet, captures the right information and it's kept up to date. So you'll want up-to-date records for things like holiday pay and statutory sick pay. Keep a clear record of the hours that people actually work, especially if people are on flexible or 0 hours arrangements. Make sure that you can record family leave and flexible working requests properly, and again, set simple reminders for key Employment Rights Act change dates and when policies need reviewing. And remember that employers are going to be under greater scrutiny with the new Fair Work agency that Chris spoke about as well. So greater penalties, greater scrutiny, and risk of where you don't comply and don't keep accurate records. Next slide. So make sure that you've got good recruitment, probation and people management processes in place. Tighten recruitment processes. As we've mentioned, early dismissals will carry a greater risk, so make sure that you're recruiting the right people at the very outset. Run structured probation reviews with documented feedback. If you need to dismiss people at an early stage, make sure that you've got the evidence of your fair reasons for doing so. and ensure that those people that you've got in place who deal with issues that are relevant to the changes, so things like harassment prevention duties, dealing with flexible working requests, the need for early performance conversations, managing sickness absence, know what they're doing, and so that your processes are consistent and fair across your business. So a lot of employment rights at risk will come from everyday management. So if you can ensure that you've got your good processes in place at the very outset, and again, it's an opportunity to make sure that you've got everything correct in any event, and that you've got your fair and compliant workplace. And so we're seeing this as an opportunity for you to do that. That's really going to put you in a great position. Next slide, please. So really sort of reflecting the fact that you should have a plan in place, make sure that you've got your timeline, that you know exactly what's happening when. So have a look at that government guidance on what's happening when with the relevant dates. Make sure that you've got your timeline covering the changes which we've outlined to you that are happening in various waves. So April 2026, October 2026, and January 2027 onwards during 2027. So there's dates that need to be confirmed sort of in the future. But make sure that you're aware of what's happening broadly when, that if there's actions that you need to take, that you've broken them down into manageable steps with realistic deadlines. Communicate those changes to your managers and to your staff where relevant. And really important, keep an eye on government and ACAS guidance because it will be published regularly and is at the moment. And make sure that you adjust your plan as details evolve because things are changing along the way. So make sure that you're clearly communicating what you need to do within your organisation, have a simple timeline with who needs to do what and by what date. And that's really, I think, all you'll need essentially to keep on track. Next slide, please.
Laura, I haven't got this poll set up, so you can go to your
That's absolutely fine. Next one. So, and there's a lovely picture of an employment team there as well. But what do you need us to do? We would be absolutely delighted to support you on this. And we are helping employers across the board at the moment, giving presentations, making sure that they're going to be compliant. And our support that we can provide to you includes the following. So we're going to have an Employment Rights Act readiness audit, which we're launching shortly. And that's going to be a practical assessment to help individuals who reach out to us and are suitable for it to assess what legal, operational and cultural gaps they might have to help you prioritise actions and build a clear compliance plan. We're going to have ongoing training and events. We have our regular employment law updates, which Chris and I are involved in. I'm sure I know there will be another one shortly, and those aren't charged for. So if you are interested, you've got our contact details and you can sign up for those. We have bi-monthly employment law newsletters that we publish that cover the Employment Rights Act regularly as well. And we can provide you with bespoke training too to support your organisation, focusing on your sector, your risk and your workforce needs. What I would say is that those that partner with us early are going to be in the best position so that we can help you ensure that you're going to have a compliant, inclusive and resilient workplace ready for the future changes. And I think it's just, again, worth giving a note of caution that these reforms are continuing to evolve at pace. Some provisions remain subject to consultation and final approval, and the devil is in the detail, and we're still waiting for some of the detail at the moment. And if you're not sure, always seek legal advice before you're making significant changes in your organisation, to your policies or your practices. And again, we're really happy to help with all of that. So I think Chris and I just wanted to say thank you very much for listening to us. We've got a tiny bit of time left. So Keris, I don't know if there's any questions that you want to field or ask or mention something about the Growth Hub.
Yeah, no, I'm just gonna don't forget the if you want part 2, that's on the 17th of March, and Yeah, so I'll just, I've been sent a couple of questions ahead of time, so from people who couldn't attend live. And please put any Q&As in the chat, and we'll try and whiz through them. I'm sure you won't mind just running a couple of minutes over. So we're looking at, if we extend the probation period, can we still do that if the performance is kind of borderline, or we're not happy with the person when a new starter comes on board?
Yeah, so there will definitely still be the option to extend the probationary period, but what you're going to have to be alive to is this new 6-month mark. So it may well be that whereas currently a lot of employers I see will do a 3-month probation with a 3-month extension, maybe they will do a 3-month probation with a 2-month extension or something like that, just to make sure that if that performance doesn't improve and doesn't get up to the level that they need it to, or they're not satisfied that it's going to within a reasonable time period, they can look to do what they need to do before that person acquires unfair dismissal protection, because once they are within a week of that 6-month mark, it becomes potentially a lot harder to manage them out.
Chris, I think I was just going to say that you could have disciplinary warnings which are issued earlier beyond that point, prior to that point of being dismissed. And I think we're aware of as a team that it's even more important for employers to make sure that fair processes are used, so that there isn't some kind of lead-up process to a dismissal that might be seen as unfair. So I think there's sort of hidden points there really for employers that basically stress that almost from day one you need to be handling these matters really carefully, a lot more carefully than you do at the moment.
Yeah, because you might be needing to rely on a warning that was given prior to the 6-month mark after the event. So yeah, it's really important to make sure you're dotting your I's and crossing your T's.
Okay, so we've got a question in the chat here. If an employee returns to work after a period of sickness, I'm assuming that they've said if it's 3 to 5 days a week, are they entitled to sick pay for the 2 days a week that they're still off? So I suppose that's like a bit like a phased return, I think they're saying.
Yes. So I'm sorry they didn't hear that particular point, but yes, that was a comment from the government that they made, that when you have day one sickness absence paid, in effect it makes phased returns to work maybe more supported, in terms of, yes, you would get payment for those 2 days, which might not have been paid previously, as would be the case now. So yes, the answer is yes, they would then be paid.
Okay, I've got another couple of questions here. An offer of guaranteed hours. Does an offer of guaranteed hours need to be accepted?
No, so we will touch on this in more detail on the 17th. But no, the worker still has absolute rights to say no, thank you, if they feel that the flexibility of the 0 hours contract is still working and delivering them what they want. It will just be incumbent upon the employer to continue making the offer at the end of every reference period, until such time as that worker is no longer within the scope. So either they're no longer a 0 hours worker, or they've got a guaranteed level hours that's above the minimum, that minimum threshold that we don't yet know what it will be. You can, through a collective agreement, contract out of these rules, but I imagine that that's probably going to be quite rare, and that people might instead just sort of look to operate a slightly different way. But no, certainly in answer to that question, the individual worker could still decline the offer of guaranteed hours.
Okay, and one in the chat here, somebody's saying if they're the only employee of the company, do they need to do all this additional documentation? I suppose the question is there, are you going to sue yourself? That's the if you've set up a company and you're the only, and you've made yourself an employee. So I suppose that's a.
Well,
have we got any other response to that?
Well, I suppose I think the risk would be a lot lower if you were your own employee. But let's say they just had one employee. There's no sort of de minimis or micro-employer exceptions here. So you'd still have to comply if you've just got one employee, particularly if it isn't you. So I don't think, you know, you can't just say I'm a very, very small employer, I'm not going to worry about these points.
Okay, and just another so what effect does the increase in tribunal time limits have on record keeping?
Well, I think employers need to be even more mindful about keeping records. I mean, even now, I would say if there's an issue in the workplace, I would still keep it for up to 6 years anyway, because there's breach of contract claims that might be brought in the civil courts anyway, if it's sort of fits that type of claim. But yes, make sure that you're keeping records, that they're accessible, and you know, Chris and I know that it can take a while for claims to be brought anyway in the employment tribunal. You've got your time limit, and then you've got early ACAS conciliation, and then it takes a long time for matters to be listed as well, and of course memories fade. So you're going to put yourself in a really good position if you followed through a fair process and you've recorded it and it's all evidenced. And people sort of come and they leave organisations as well. So yeah, I think the key is really just to make sure you're keeping a track of everything, carry out fair processes, and make sure it's documented and kept.
Okay, and this last question, there's no more in the chat, so we've got for this last question, if you've got any burning issues, just put them in there. So the last question is there a requirement to top up statutory pay?
There is no requirement unless you've created some contractual obligation, let's say in a contract of employment or a staff handbook that's contractual, or potentially by way of custom and practice, so it's become a contractual right in that way. But if you haven't got anything in place at the moment, then no, there wouldn't be an obligation to give enhanced sick pay over and above statutory sick pay.
Yeah, I agree with that completely, Laura. And the added complication that I've seen a few times actually is where enhanced pay is being used at the employer's discretion. I think as soon as you're using discretion and becoming slightly less consistent with how you're applying something, you are opening yourself up for the potential for a discrimination complaint. Someone will say, even if that's not the reason why you're treating people differently, that's not how it may be perceived. And you know, there's not only good claims out there, and even the bad ones need to be defended, and that has a burden on a business. So it's just better to be consistent rather than sort of looking to think, well, you know, does that person work hard enough for me to give them an enhancement or whatever it might be.
Or just be careful in your justification, and that it genuinely is discretionary rather than just paid as a matter of course, and you call it discretionary and it becomes contractual.
Yeah, definitely.
Well, thank you for that. That was really comprehensive and loads of stuff there that I think it will be sort of baffles people's minds. A couple of people said, "Will I be sent a link of the recording?" I think a few people want to watch that back, as well as if there were the people that missed it. So thank you to everybody who has joined us live and who is watching this recording. You've got all the contact details there on the recording there, and please feel free, that link is live, so you can share that around to colleagues or to other businesses who you think might be interested and need to hear this. I think one of the things that there's quite a lot of big headline stuff which is and I think the detail is really kind of missing. I think we've only really seen kind of media reporting of this and not kind of and not sort of HR briefings on this. So I think there's a lot to dig into. So thank you very much for that. I think I'm on my last slide. And so that's Stephens Scown. I'm probably legally obliged to say other employment support is also available. Do your own research. This is not an endorsement, but thank you very much to Chris and Laura for running through that for us. And hopefully I'll see you at the some of the other events and the second part of this on the 17th. Thank you very much.
Thanks for having us, Keris.
Cheers. Bye.
Bye-bye.